The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, Madam Clerk. I want to welcome the lawyers this morning to the Fourth Circuit Court of Appeals. We'd like to be with you in Richmond, but we can't be there, so this is the best we can do. Our first case is Variety Stores, Inc. versus Walmart. And we have cross appeals, and both the lawyers for the parties will argue twice as a result. And the first, we'll recognize Mr. Pizzella, speaking for Appellant Walmart. Mr. Pizzella, you there?
I am, Your Honor.
It's good to have you with us, sir.
Nice to be here. Thank you for having me.
Go right ahead.
May it please the court. Mark Pizzella from Warwick, Harrington, and Sutcliffe on behalf of the appellant Walmart. Our brief set out several errors related to liability, willfulness, jury reassembly, and remedies, but I'd like to begin with a bit of context. This is a 6-year-old trademark dispute between two large retailers concerning inexpensive grills and grilling accessories. The parties use different marks that use different words in different fonts, in different sizes, and incorporating different logo elements. The only thing the two marks have in common is the word backyard, which by Variety's own admission is a word that is widely used on grilling products. Walmart didn't choose its mark to evoke Variety or any of the other companies that use that word. It chose its mark to describe what its product is, a backyard grill. After 3 trials and now 2 appeals, it remains undisputed that there's no evidence that Walmart's decision to use its mark ever confused a single consumer in the real world. Walmart sold hundreds of millions of products over a period of years, and Variety never identified a single confused consumer. Liability in a trademark case turns on the likelihood of consumer confusion. What better evidence of the absence of a likelihood of consumer confusion could there be than the absence
But didn't the jury hear all this? Don't we owe some deference to the jury's verdict after hearing all this?
Yes, Your Honor. However, on the evidence presented at trial, which is a more complete record, no reasonable jury could conclude on the 4 factors that this court remanded the last time around that Variety had carried its burden. There was no evidence offered on commercial strength. This court found that as to conceptual strength, Variety's mark was weak. As to commercial strength, Variety offered only indirect evidence of commercial strength that itself missed the mark. But beyond that, the testimony on direct evidence of commercial strength was that Variety's mark was not a national big-time brand. That's a JA 782. It was unlikely that there was very high awareness of backyard. That's a JA 809. And that neither of the parties' marks are very well known. That's a JA 811. Given that context.
Mr. Pizzella, it's Judge Floyd. In your brief, you did not address factors 3, 4, 5, 8, and 9 on the test for likelihood of confusion. If those factors favor Variety, is that enough for a jury to find likelihood of confusion?
No, Your Honor. And very specifically, this court in Grayson, George, and Care First has affirmed summary judgment in favor of defendant. Their marks were weak, dissimilar, and there was no evidence of actual intent or actual confusion. That is this case. So in those 3 cases, this court affirmed summary judgment for defendant. Those facts align precisely here. So putting aside those other elements, those four critical factors all weigh in favor of Walmart, and no reasonable jury could conclude otherwise. Now, I'd like to address willfulness in particular, if I could, just for a moment. So apart from the liability finding, the court should direct entry on no willfulness, or at the very least, the question of willfulness should be remanded and retried, because the trial court erred in failing to instruct the jury. The key error in both the district courts and Variety's willfulness theory is that they conflate knowledge of another's mark with willful infringement of that mark. That's wrong as a matter of law, and it requires reversal, because at the absolute most, Variety could show only that Walmart knew about Variety's mark. Knowing about a mark is not enough under this court's precedents. The willfulness finding is also separately subject to remand, because the court erred in failing to instruct the jury on this term of art, which is required.
Was there a specific interrogatory on the verdict form about willfulness?
Yes, Your Honor.
Okay. But there was no instruction about willfulness.
Correct, Your Honor. So the jury was at sea as to its meaning.
And you say that was error not to instruct on willfulness.
Correct. Willfulness is subject to a whole host of different meanings. But
so what's our standard of review on that point?
That's clear error, Your Honor. The failure to instruct on the term of art is clear error.
But the other side says you waived it. That would make it plain error, wouldn't it?
Two answers there, Your Honor. One, there was no waiver. Objected.
But Variety's position is it was waived, and that the willfulness instruction issue is here on plain error review. That's their position. So you need to tell me how you shoot that down. Okay.
It is plain error, Your Honor. The failure to instruct on a term of art is a plain error. The law.
But you'd say it's not plain error review.
The failure to instruct is plain error, Your Honor.
So are you admitting that? Go ahead, Judge Thacker.
Oh, that's just for the way I look at the record. There was an objection, but not really to the instruction about willfulness. I mean, you objected in one place, but that's a different instruction from what you're arguing now, isn't it?
There are two arguments on the willfulness issue, Your Honor. One, as to the failure to instruct, we objected in a separate filing, which is at JA 413, and at the charging conference, which is JA 428. Okay. That failure is error, and in addition, putting aside waiver, assume waiver, the court had an independent obligation to define a term of art, and the court failed in that obligation because the jury was obligated to only find willfulness where the defendant intentionally attempts to confuse the public or intentionally attempts to free ride on Variety's goodwill. Variety offered no evidence on either of those legal standards.
Mr. Roselli, you offered a willfulness instruction, as Walmart did, and then it was discussed specifically at the charge conference. Isn't that right?
That is correct, Your Honor. We offered a willfulness instruction at JA 413.
And it was discussed at the charge conference.
Correct.
Okay.
Correct.
And it's your position that's enough to preserve the issue for appeal?
Yes, Your Honor, but separately, the court had an obligation to instruct the jury.
I understand, but even if it's not, and even if it's
Correct.
not enough, that you satisfy plain error review.
Correct.
But I don't know, if I were you, I'd be willing to give up the proposition that's not here on plain error review. You ought to be arguing, I think, that here on the harmless error review, and that it was properly preserved.
You're exactly correct, Your Honor. It was preserved.
But the other side can argue, they'll be arguing us on plain error review because that helps them. But here, you don't want it to be a plain error review. I wouldn't if I were in your shoes, but you can do however you want.
Your Honor, you're exactly correct. As to the first argument is not plain error review, and we preserved the argument as set forth in the brief and the separate filing and at the time. But the court's to instruct was plain error review.
And you want a new trial on the on liability, and that would necessarily vacate the damages awards, and we wouldn't have to address anything else on a. You'd get a new trial on everything, would you?
You're correct, Your Honor. You would.
If you're right on this instruction, on the willfulness stuff.
You're correct, Your Honor.
All right. I'm sorry, I didn't mean to interrupt you. Goodbye.
Not at all. I'd like to make sure I discuss the monetary remedies rulings, and I'll start with a critical procedural error by reassembling the jury 110 days after the jurors were excused. Reassembling a jury requires a careful consideration of the potential for prejudice after the jury is initially discharged. The Supreme Court's decision in Dietz holds that even a few minutes between discharge and reimpanelment may be impermissible. Here, 110 days passed. Dietz instructs that prior to reassembly, the court must engage in a multi-part test to determine whether reassembly is proper. The trial court refused to apply that test. Dietz also instructs that the court should voir dire the jurors to assess whether they were exposed to information about the case after they took off their juror hats. The trial court refused to do that too. Explaining.
Now, opposing counsel points out that the court told y'all at the end of the liability trial that the same jury was going to be brought back for the damages trial, and points out that you didn't object to that. Does that change your argument or our analysis in any way?
It doesn't, Your Honor, because the court's comment at that point was entirely conditional on whether Walmart submitted an interlocutory appeal or not, and Walmart did submit a request for an interlocutory appeal. So in fact, there was no opportunity.
Didn't the court also say all this can be sorted out later? We don't have to deal with it now? So indicating, at least to me, that it wasn't imminent and there was no need for you to object at that point.
Correct, Your Honor.
You have to show actual prejudice about this jury question.
We do not under Dietz, Your Honor, and that's actually the point of Dietz, is that the burden is not on the person in Walmart's position to demonstrate prejudice. The court has to apply the legal test in Dietz and voir dire the jurors to avoid even the potential for prejudice. There's no obligation on our part at this stage to show the prejudice, and in fact, we were completely denied that opportunity by Judge Boyle's failure to voir dire the juror.
Well, did Judge Boyle actually voir dire the jury in any manner?
No, not in connection with the reimpanelment, Your Honor. He merely instructed them not to rely on information they learned subsequent to their first discharge. I'd like to address the remedies because another retrial may be unnecessary if the court agrees with Walmart's errors on remedies. Walmart stopped using the mark in 2016. So Variety would not be left without a remedy. The typical result in the trademark case is an injunction, which is the practical result here. Variety sought damages under two theories: actual damages in the form of a lost royalty and disgorgement of profits, and neither can stand. With respect to royalty, Variety identified no lost sales and no actual damages. It sought lost royalty as actual damages, but when it comes to a lost royalty, the overwhelming weight of the law establishes that you need some licensing history. No circuit court has ever allowed a plaintiff a lost royalty absent evidence of a prior licensing history. That should end the inquiry. Variety didn't demonstrate a licensing history from which it could demonstrate an entitlement to actual damages in the form of a lost royalty. It also failed to demonstrate the amount of a royalty with any precision. Its expert put forward a 5% royalty, and he arrived at that figure by looking at what he claimed were comparable licenses. But as a matter of law, he had an obligation to demonstrate that they were in fact comparable. And the evidence was entirely one-sided, that those comparable or so-called comparable licenses were for national brands like General Electric and Better Homes and Gardens, which the expert conceded were much more widely known than Variety's mark. So there's no basis, even if there were an entitlement to a lost royalty, there were none, to arrive at a figure. So Variety failed to carry its burden to prove that it would have earned a royalty and the amount. So the jury's $45 million.
If we agree with you that you should get a new remedies trial, do we need to reach this issue about the royalties?
Strictly speaking, no, but the issues in this case have gone up and down twice, and it would certainly
But if we start reaching those issues after if we were awarded a new trial, it would be simply an advisory opinion.
The court could avoid that by just addressing the remedies directly and finding as a matter of law that there's no entitlement on these facts to a royalty or
But it would be an advisory opinion if we were going to grant a new trial based on the problem you argue about the jury being reassembled.
Well, Your Honor, as a
Look
matter
to me
of
like that would end the discussion. Just like if we, on the first issue, were to agree with you on the willfulness instruction, that would end the issues relating to the case. Otherwise, we get into advisory opinions. We have enough problems with cases that really mean something, with issues that really mean something. Anyway, I'm musing. You go right ahead and answer Judge Thacker's question. I interrupted you.
Judge Thacker, could I trouble you to repeat your question?
I think you did answer it. My question was just, do we have to get into the royalties if we agree with you on the new remedies trial? And you said, strictly speaking, no. And then you were making your argument about how you would like us to determine that as a matter of law anyway.
Correct, Your Honor. My time is up, so if I could just close briefly.
You go right ahead.
At a minimum, Walmart's entitled to a new trial. The judgment's riddled with both procedural errors and irregularities, most notably the improper reassembly of the jury. But this court can and should reverse the judgment outright. Every basis for monetary recovery Variety offered is purely theoretical. There's no consumer confusion, no harm to sales or goodwill, and no basis for the massive award in this case. The court should reverse and end this dispute. Thank you.
Thank you, Mr. Prezella. Now, Mr. Adams, are you there, sir?
Your Honor.
Good to have you with us, sir.
Pleasure to be here.
Go right ahead.
Good morning, Your Honors. May it please the court. From Walmart's argument, you would scarcely know that we have been here once before. The mandate to the district court included this court's finding that 5 of the 9 factors it considered were either waived by Walmart or were in Variety's favor. For the remaining 4 factors, strength, similarity, intent, and actual confusion, this court concluded that there were genuine issues of material fact that required a jury determination. In fact, at one point in the opinion, it says, quote, whether Walmart's mark created a likelihood of confusion is indeed a question for that jury, consisting of ordinary consumers, and using the 9 factors as a guide is well suited to evaluate, close quotes. Now, Walmart is back to tell this court that its opinion and mandate were all wrong, that the same evidence that this court said created genuine issues of material fact were, in fact, when submitted to the jury, so lacking that no reasonable jury could have credited it in arriving in its verdict of willful infringement. To the contrary, much more evidence supporting Variety's position on the 4 remaining issues was presented to the jury that was before this court on Walmart's appeal from the district court's summary judgment order. That's typical. Typically, summary judgment cases are on essentially a written record, which was the case here. In addition, all the additional evidence that Variety relied upon was from Walmart itself. Walmart knew about Variety's backyard registration, and this court said in its slip opinion that it could, quote, support an intent to infringe. It was a genuinely disputed issue. Walmart visited other competitors, even though it had no information that these competitors were using backyard. On the other hand, even though Walmart did know that Variety had a registration, it took no steps whatever to determine what, if anything, Variety may have been using its mark on. And another factor that came out was the shifting testimony of one of Walmart's witnesses, who initially said, in an effort to divert attention from their knowledge of Variety's trademark usage, initially said that there was another third-party user out there that was also using backyard barbecue. When that didn't turn up, the testimony shifted to the fact that there was a trademark registration that they had found. When that didn't turn up, I actually confronted the witness, who conceded that yes, it actually potentially, that was the term that was used, potentially that party that they referred to as a third party might have been Variety itself. That testimony went to the issues of infringement, likelihood of confusion, and willfulness. But there was other information that was told to the jury. $770 million of the sales that Walmart made were made after we specifically objected to their usage by filing the Trademark Trial and Appeal Board action. And half of their sales were made after we filed the complaint. Walmart knew about Variety's backyard registration, but made no effort to investigate how Variety was actually using the mark. Those factors were clearly sufficient to allow a jury to find for Variety, both on the infringement issue as well as on the willfulness issue, exactly as the Fourth Circuit said in its remand order.
What about the lack of the willfulness? What about the lack of the willfulness instruction? Focus on that. They didn't get the willfulness instruction.
Walmart doesn't cite any evidence.
And you're emphasizing that they have to prove it's willful. You had to prove it was willful, and they didn't get a willfulness instruction.
2 points. First of all, the few cases that Walmart cites do not support their position that the term willfulness necessarily requires a specific instruction. But the significance here is that, and we made a point of this in our brief, was that Walmart came back to the remedies trial with what we referred to as a do-over. In other words, even though the court had already determined in the liabilities trial that the infringement was there and that it was willful, their evidence was that they kept using the synonyms. In other words, there was a great deal of context during the trial testimony about what it was that we contended was willful. And Walmart used the term intent, they used the term willful. They asked their witnesses over and over again in the context of these various events that we've been discussing, whether or not you intended to infringe Variety's trademark, whether or not your usage was willful, and so forth and so on. And so the jury had...
Mr. Adams, this is Judge Floyd. With regard, in the context of a trial like this, the plain meaning of willful is not appropriate. I mean, the legal definition of willfulness must include intended to infringe. Do you agree with that?
There is no requirement in the Fourth Circuit that there be a specific intent to infringe. And there's a case called Seroy, which the Fourth Circuit case, which makes that point expressly. But let's remember one thing, that under the law, willfulness is not required for an award of profits or damages. And in fact, in this case, Walmart fared quite nicely. The jury, for whatever reason, concluded that they should keep 80% of the profits they made. In other words, they made about $250 million in profits, and the jury allowed them to keep 80% of it. And as far as the royalty is concerned, the royalty they awarded was at the very low end of all the testimony. So so
you're saying they can infringe by accident. You're saying you can prove it that they infringement by accident, right?
No, not by accident, but the courts have said that you don't have to show.
Well, you said they don't need to intend to infringe.
But it's inferred, Your Honor. This court's own opinion in this case says that it can be inferred. Willfulness can be inferred one way or the other. And in fact, there's this is worth reading. There's a statement that Walmart made to the district court characterizing the Fourth Circuit's opinion.
But if it's a jury trial, the jury has to find the intent to infringe, willfulness.
But they can do that. They can do that by inference.
It's not a question for the court. It's a question for the jury.
Exactly, and that's what the jury.
It can't be accidental. It has to be intentional.
But the intention is almost always determined by an inference from the evidence. No one ever says I intended to infringe. It's always by inference. And this, I want to refer, it's in our brief at opening brief at 38 and 39, but this is Walmart's own language. Quote, the Fourth Circuit recognized that because no testimony was ever given regarding the substance or character of legal advice given to Walmart, the fact finder could draw an inference in Walmart's favor that it followed its counsel's advice and acted in good faith, as the Fourth Circuit concluded, or the fact finder could draw an inference against Walmart that it ignored its counsel's advice and acted in bad faith. Now, when Walmart says here, parenthetically, that as the Fourth Circuit concluded, the Fourth Circuit was construing that in Walmart's favor, of course, as it had to do in reviewing the summary judgment grant. But there's
just Judge Floyd, what you said may well be true, but we're talking about an instruction to the jury. Sure, they can infer intent, but they have to be told what willfulness is, and that is intended to infringe, and it may be proved by circumstantial or direct evidence. I mean, should the jury at least be told that?
No, and Your Honor, I think in this particular case, as I said, there was a lot of evidence before the jury as to exactly what the parties meant when they were referring to intentional or willful evidence. But I don't want to leave open Walmart counsel's arguments about a waiver, because under Rule 51, Walmart had an obligation to raise that issue with the court, and it never did. The only thing Walmart ever did was submit 2 or 3 weeks before trial a set of proposed jury instructions, but the judge gave.
So your position is that they waived the jury instruction?
Yes.
The willfulness instruction, is that correct?
The district court gave the parties 2 different opportunities to raise objections to its instructions. There was no charge conference as such. The judge came in with a set of instructions, asked the parties to look them over and to make any objections. This is before the instruction, of course. And Walmart made a half a dozen different objections, but never said anything about willfulness. Then, after he instructed the jury, in other words, after the jury had already been instructed, he called the parties up to the bench, and out of the hearing of the jury, asked the parties again, is there anything that I said that I shouldn't have, or is there anything that I need to add? Again, Walmart had, it's on the record, Walmart had 2 or 3 different instructions it wanted, which the judge denied, but it never said a word about willfulness. And I think we have to look at this as a practical matter. Because of the evidence and the fact that the jury actually ended up hearing the evidence twice, the jury had a clear understanding of exactly what willfulness meant. And if you look at some of the instructions for willfulness, all that it amounts to is a list of synonyms: deliberate, intentional, willfulness. They all mean the same thing. And clearly the jury understood that. And Walmart's counsel had opportunities during his oral argument, which he accepted and did, to further argue his position on willfulness, and it wasn't successful. But I think the gut question here is it really?
What's the standard of review? What's the standard of review on this issue then?
In a situation where it's where there's a waiver, it has to be plain error of a sort that basically, if the error isn't corrected, it does a manifest injustice, and that clearly is not the situation here. Walmart had.
Now we hear about that a lot in criminal cases, not so much in civil cases. So you say that applies in a civil case like this, that this thing should be here, this willfulness and obstruction issue is here on plain error review.
Well, I would think in this case, Your Honor, since this is a civil case, that any likely prejudice would be substantially less than you might incur in a criminal case. But certainly in
it's all money. I mean, and then that's but here it's a pretty big sum. But I'm just trying to get an answer from you. Your position is it's here on plain error review. It wasn't preserved.
But I want to emphasize,
the judge didn't get a chance to fix it.
I want to emphasize again that there's no requirement anywhere in the Lanham Act that there has to be willfulness for there to be an award of profits or.
All right, assume, but I'm not. I assume that willfulness has to be proven. If what you say it was waived, it's here on plain error review, correct?
Yes.
All right.
And I want to just.
He says it's not here on plain error review, but if it is, he satisfies plain error.
Absolutely.
It was preserved.
Yeah, I think the question is it really worth going back and doing this whole thing over again? As Mr. Puzzella says, this case has been going on for 6 years. To do the whole thing over again, all of liability and all of remedies, because.
Or you're falling back on a position of so what then?
Well, yeah, but I have to emphasize that we're talking about willfulness.
So what? Well, if they say so what, it's $95 million. That's what it is.
Your Honor, with all respect, we're talking.
Not much you can say it real fast, I guess.
We're talking about an issue which doesn't matter as far as the money is concerned. But the law is quite clear that you do not have to prove willfulness to prove profits or to be able to recover profits or royalties. The reason the issue of willfulness came up is because the language of the Lanham Act, which requires which allows the court to treble damages in a certain case, which is usually willfulness, and also in this court's opinion in synergistic, and one of the 6 factors it mentions is intent. But your point on this issue,
your position then, besides being waived and everything, is that you didn't have to prove willfulness anyway.
No, but there's one more. There's one more.
No error at all in that case.
Right.
If you didn't have to prove willfulness, and there can't be an error on failing to give a willfulness.
I need to mention, and that is all of this was reviewed independently by the district court under synergistics after the jury reached its verdict. The court, in its synergistics opinion, referenced all these issues specifically, and so there was an equitable overlay on this issue. If Judge Boyle had, in hindsight, thought that perhaps, and believe me, Walmart made this argument. If Judge Boyle had thought that, and perhaps it would have been better to have a more detailed instruction on willfulness, he could have corrected it in his synergistics opinion, which he issued 2 or 3 weeks after the trial was over.
Yeah, I don't know how much time you have left, but speaking of after the trial was over, I really would like you to address the 110 days between the liability phase and the damages phase, and bringing the same jury back. Because
I appreciate that, Your Honor. I'm actually into the red, but give me a minute or two to do that, if you would be.
You go ahead and answer questions from Judge Thacker or Judge Boyd or me. As long as we have them, you go right ahead.
Thank you. When the district court first mentioned the possibility of a bifurcated trial, and he said, I'm going to bifurcate this trial. What he said was, if the parties agree, I may consider allowing an interlocutory review. That way you can go up on the issue of liability, and if Walmart wins, you don't have to come back. If they do, you come back and we'll have a trial. We'll use the same jury. Well, what did Walmart do? We didn't agree on an interlocutory trial. We wanted to go ahead and have a trial on remedies. Well, so there was a 110-day gap between those 2 trials, but what did Walmart do? They filed a motion for interlocutory appeal, which the judge denied. But if he had granted it, there would have been a delay of 9 months to perhaps as much as a year.
Fine, but it's not as much, I'm not as concerned about what Walmart did as what the district court did not do. Was there any voir dire at all of the jury after 110 days?
No, I don't think.
Why isn't that a problem?
I don't think it is because, as again, I don't know what the voir dire would have been directed to. This case was a non-issue in Elizabeth City, North Carolina. There was absolutely no media coverage.
Is that in the record? Is there anything in the record that shows that it was a non-issue in Elizabeth City, North Carolina? That Walmart got hit with a $95 million verdict?
My point was that
got hit with a liability verdict.
Walmart could point to nothing in the way of any type of media coverage or that could have prejudiced the jury.
But Dietz doesn't require actual prejudice, does it?
Your Honor, there are several cases in the Fourth Circuit that say specifically that you cannot fault a judge for not conducting a voir dire if it's mere conjecture or speculation.
I'm still talking. I'm talking about Dietz in the Supreme Court, not the Fourth Circuit. Does Dietz require actual prejudice?
No, but Dietz was not a bifurcation case, first of all.
Okay.
And
my other question is, you're talking about how Walmart couldn't show prejudice or any problems in the media, but how could they when there was no voir dire? That's what the voir dire would be for.
Your Honor, I think that the district court was concerned, and we were very concerned, that all Walmart was trying to do was to provoke a mistrial. The courts have said repeatedly that sometimes when you voir dire a jury, what you're doing is simply inviting them to go out and look for things that they might not have thought of otherwise. Walmart had already lost, as you say, $95 million verdict. And so their strategy at this point was to come back and perhaps browbeat the jury into a situation where they could file a motion for a mistrial. And that's really what they've done here. They've asked the court to go back and basically redo the whole thing over again without any evidence that there was any media coverage or anything at all that would have resulted in a biased jury. Remember, every one of the jurors in this case was a regular Walmart customer. They had already concluded that Walmart was a willful infringer. So it's hard to imagine what additional information there might have been that would have had any effect beyond what the jury already knew.
I don't have any other questions. No, thanks.
Judge Floyd?
No.
Very good. Thank you, Mr. Adams.
Thank you, Your Honor.
Back to you here in a few minutes. Mr. Pizzella?
Yes, Your Honor. I want to make sure I was clear on the willfulness instruction issue. We proposed an instruction and objected to the failure to give our instruction at the charge conference. We specifically made a record. Because we made that objection, we need to show only that it was an abuse of discretion not to give an instruction and that the error was not harmless. If you disagree,
you objected at the charge conference, Mr. Pizzella?
Yes, Your Honor. Rather than going back and forth with variety on the record, I would just invite the court to look at JA 413, JA 431, and JA 840. The record was preserved.
What's the last one there?
JA 840, which is the transcript, Your Honor, where we objected at the charge conference. One thing that was omitted in the argument that we just heard was that during the trial, in addition to the jury instruction that Walmart offered, Walmart separately moved to strike testimony from Variety's general counsel concerning willfulness and for an additional willfulness jury instruction. And that motion was denied. So there's a additional objection here that you might not otherwise see. There should be no question whatsoever as to the preservation. right? So that is an abuse of discretion standard. If you disagree that we preserved the error, which we plainly did, I think, review is still for plain error, and the error is plain for failure to instruct on a term of art. But getting to the merits of that, the evidence on willfulness was paper thin. It only amounted at best to Walmart's knowledge of Variety's use. That's insufficient as a matter of law. There was nothing beyond that. There was nothing demonstrating an intent to confuse the consumer and an intent to infringe, an intent to free ride on Variety's goodwill, which itself would be nonsensical given their concession that there was no goodwill. So there was insufficient evidence for a finding in support of willfulness. And that's why Variety is digging in so deep on this issue, because all they had was mere knowledge. And mere knowledge is insufficient as a matter of law. And the willfulness issue infects everything. As the court noted a moment ago, synergistic as one of its principal factors, the defendant's willfulness and its infringement, that colors everything in that equitable balancing. It's critically important. Turning to, unless the court had any other questions there, I wanted to address the cross appeal for a moment. Just a brief word. To be clear, you don't have to reach the issue if you're remanded for a new remedies trial. But we do think that the court can find, for the reasons stated in our brief and those found by the district court, that the issue was abandoned and should not be considered in any remedies retrial. The issue of the unfair competition claim is not one about a motion in limine and whether that was the basis to raise it. The issue is that Variety didn't include that claim in its jury instructions, didn't include it in its verdict form, both of which were later in time than any other papers that may have included that claim. And after the liability trial, they didn't ask for a directed verdict on that claim. They did nothing. So the liability trial concluded, liability was over, and they said nothing about that unfair competition claim. The notion that it wasn't
Mr. Priscilla, that might be true, but let me ask it this way. Should we affirm the district court on this matter if we believe it was procedurally incorrect to dismiss a claim by way of a motion in limine?
Yes, it should be affirmed because it was waived. And it was waived through Variety's course of conduct. It didn't. So
your argument's purely that it was waived, and the fact that it occurred that motion in limine was made and granted has nothing to do with it.
Correct, Your Honor. It was waived, and the nature of how it came up in the course of the proceedings is essentially irrelevant because the waiver occurred previously. I'm in the red, so unless the court has any other questions, I would just like to close with Walmart's entitled to a new trial, and the court should reverse and end this dispute on damages to avoid any further proceedings. Thank you.
Thank you, Mr. Pizzella. Mr. Adams?
Yes, Your Honor. One point before I begin otherwise, and I should have mentioned this previously, and that is the decision on willfulness was an advisory opinion. And this court has said repeatedly that willfulness and intent are equitable considerations. As I said a few moments ago, the district court did a separate analysis based on equitable principles as a part of its synergistics effect analysis, and concluded that based on his equitable judgment that the willfulness finding was correct. Now, on to the question of our the motion in limine and an unfair competition claim. Walmart moved for JMOL twice on our unfair competition claim, and it was denied twice. Then it turned around and filed a motion in limine to prevent admission of prejudicial evidence. This was not a substitute for a JMOL motion. There was no waiver by Variety. Its unfair competition case was in this case from the very beginning to the very end. The problem with Walmart's argument is that it does not understand, or it chooses to ignore, the way this is handled under North Carolina law. And I can refer the court to the Polo v. Craftex case, which is referred to in our brief at page 65, where the court said we need not consider whether under these circumstances the plaintiff was entitled to an award of damages under the Lanham Act, for it clearly was entitled to such an award upon its common law claim of unfair competition and its claim under North Carolina's Unfair Trade Practices Act. Walmart did not move in limine regarding the counts 3 and 4 of our complaint, which relate to common law trademark infringement or common law unfair competition. So just as under federal law, here there is no case law in the North Carolina law that says that unfair competition per se bars damages based on a royalty without a prior licensing history. Those two factors come together very clearly. So Walmart is simply wrong. It used the motion in limine as a subterfuge to get the unfair competition claim out of the case. Now, in the pattern jury instructions in North Carolina, this is set out in our brief, you don't give a jury instruction to the jury on unfair competition. You give factual issues to the jury, and then the judge decides as a matter of law whether those facts result in an unfair competition finding. That's what happened in Polo. It's what happened in Exclaim. There are numerous other cases that accomplish exactly the same result as should have happened in this case. There simply was no waiver, and for that reason, it was improper for the court to rule that we had waived it because we didn't ask for jury instructions on unfair competition, or we didn't ask for a verdict blank on unfair competition. In fact, if you look in the pattern jury instructions, the only unfair competition instruction is basically one on causation. And there was several causation instructions in the jury instructions on causation. So there was no reason for the judge to go further.
Now, if we agree with you, do you want the same jury brought back, or do you want a new jury?
If you agree with me, we would ask for the same jury because they will remember a large part of what the case was about, whereas any other jury wouldn't know anything about it. So yes, I mean, without conceding for a moment, it would be appropriate to reverse the case or send it back for a new trial. Clearly, given the choice, we'd much prefer to have the jury that was there than a brand new jury.
Anything else?
Well, I'll just point out, Your Honor, that the judge asked the jury at the beginning of the remedies trial, he told the jury, he read the jury a statement, and he told the jury in some length of their duty to decide the case only on the evidence they heard in the courtroom. He told them that they had taken an oath to do that. And after he finished, he said, "Y'all understand that?" And according to the court reporter, all the judges responded affirmatively. So there are Fourth Circuit cases that say that simple speculation or conjecture about jury prejudice is not sufficient to reverse a case because of a judge's discretionary decision not to have a supplemental voir dire. So if you have no further questions, thank you very much, Your Honors.
Thank you, Mr. Adams. If we were in Richmond, we'd come down and shake hands with the lawyers and thank them for doing a good job, but we can't do that here. But we can thank you for being with us and doing a good job. And Madam Clerk, we can take this case under advisement. Unless Judge Floyd or Judge Thacker would like a recess, we can call the next case.
Thank you, Your Honor.
This is Akers versus the Maryland State Education Association.
That's correct.
And Mr. Mitchell, you represent Akers.
Correct. Represent the appellants, Ms. Akers and Ms. Moselle, the plaintiff's appellants.
Yeah. Good to have you with us, sir.
Thank you, Your Honor. Good to be with you as well. Thanks for having me. May it please the court. Property that has been taken in violation of another's constitutional rights must be returned, even if the defendant took the property in good faith, and even if the defendant took the property in reliance on a statute or court ruling that purported to authorize its unconstitutional conduct. This court can assume the existence of a good faith defense under Section 1983, and it can assume for the sake of argument that private parties can assert a defense that resembles qualified immunity, consistent with rulings from other courts of appeals that have recognized—
Mr. Mitchell,
Yes.
Mr. Mitchell, what makes this case different from all the cases in the other circuits where courts have held that unions are not required to repay representation fees paid to them before the Janus decision?
Factually, there really is no distinction, Your Honor. There's no basis on which we can say that this case presents a different set of facts from the cases that were presented in those other courts. And Your Honor correctly observes that the other courts of appeals so far to have considered this issue, I believe we're up to 5, have upheld the notion that the union can assert a good faith defense in this situation. But with all respect to those courts, we don't believe they've answered or refuted the argument that we're advancing before this court. And in some of those cases, not all, but in some, this argument was not even presented. The claim we're making is somewhat more nuanced than denying even the existence of a good faith defense. What we're saying to this court is that even if one assumes that the good faith defense exists under Section 1983 and that it's available for a private party to use, the scope of that defense will shield the defendant only from a remedy of damages, not from a remedy of restitution. There's a fundamental distinction in our view between a remedy that forces a defendant to pay out money in compensation for a harm that has been inflicted, as opposed to a remedy that merely requires a defendant to return property or money that it never should have been allowed to take in the first place. And none of the other courts of appeals that have rejected the position that we're advancing today have addressed this contention, nor have they distinguished the authorities that we're relying on in our brief. And Judge Thacker, there's no strength in numbers when it comes to deciding a question of law. These decisions from other courts are not binding authorities. They can be followed only if this court, in its independent judgment, finds the reasoning of those cases persuasive. So the brute fact—
But you want us to but you would have us create a circuit split. Correct?
I believe that's right, Judge King. I don't think there's any way to rule in our favor without creating a circuit split, unfortunately. And there may be some understandable reluctance to do that in this particular situation. But again, we don't believe the mere fact that other courts have ruled the union's way is controlling here. It's certainly not controlling, doesn't compel an outcome in the union's favor. The union still has to show why those decisions from other courts were correctly decided. And more importantly, the union needs to show why the specific argument we're advancing today is wrong. And there's nothing in those other opinions from the courts of appeals that has effectively distinguished the cases and authorities that we're relying on, which have consistently held that when a defendant acts in reliance on a statute that is believed to be constitutional at the time it acts, and that is later declared unconstitutional, the defendant still has to return the money or property that it took in admitted good faith, but in violation of another's constitutional rights. One of the best cases.
Mr. Mitchell, this is Judge Floyd. Did you use the term or argue the concept of restitution below?
Yes, we did. That was the theme throughout our district court briefing, not only in this case, but in other cases similar to this that we've brought in other courts.
But you did, my question, I guess, did you actually use the term restitution?
I'm almost certain we did. I haven't read my district court briefing in preparation for this argument, but the distinction that we have drawn throughout this litigation, not only in the district court, but also in every court of appeals where this case has been litigated, has been a distinction between a remedy for damages on the one hand and a restitutionary remedy on the other. So a remedy that simply compels the return of property or money that was taken in violation of the Constitution, even if it's taken in good faith, still should be returned to the rightful owner. And to answer Your Honor's question, I will pull up my district court briefing just to confirm that the word restitution appears in the briefing that we submitted below. But Mr. Diane has never suggested in his brief that we waived or forfeited this argument by failing to raise it in the district court. This has been the argument that we've been making throughout the litigation. So again, consider United States against Windsor. This is a case where the IRS had collected taxes in good faith reliance on the Defense of Marriage Act before the Supreme Court had declared the Defense of Marriage Act unconstitutional. The government's good faith reliance on that statute did not allow it to keep the taxes that it had collected from Ms. Windsor in violation of her constitutional rights, even though the good faith would have protected individual tax collectors from lawsuits for damages if Ms. Windsor had sued them for emotional distress for the dignitary harm that she had suffered from not having her marriage recognized. There's the distinction again between a remedy for damages in which qualified immunity or good faith can shield the individual officer, and a remedy that seeks simply restitution, return the taxes that you never should have been allowed to take in the first place. When the FBI searched Congressman William Jefferson's office in reliance on a search warrant that was later declared unconstitutional, the FBI still had to return the documents that it had seized from Congressman Jefferson in violation of the speech and debate clause. The FBI's good faith reliance on the search warrant would immunize it from lawsuits for money damages, but it still had to return the property that was taken in violation of the Constitution. And then consider Wyatt against Cole from the Fifth Circuit on remand from the Supreme Court. In that case, property that was seized in good faith reliance on a replevin statute that was later declared unconstitutional had to be returned, even though the defendant who seized the property was awarded a good faith immunity from damages that arose out of the unconstitutional seizure. So neither good faith nor qualified immunity, either of these defenses, even though they will apply in a Section 1983 lawsuit, they won't extend to the point that they allow a defendant to escape a restitutionary remedy. These defenses, to the extent that they exist, can confer only an immunity from damages for the collateral harms inflicted by an unconstitutional seizure of property. But no one winds up getting a windfall for violating the Constitution, even when the violation occurred in the utmost good faith. There's been a lot of discussion in the briefing about the notion of fairness and equity, and whether it would be fair or equitable to require the union to return money that it took from the plaintiffs at a time when the actions were believed to be constitutional, and at a time when the actions were explicitly authorized by a state statute. But this is actually the paradigmatic situation for Section 1983 liability. Before Monroe against Pape, the only way you could sue someone under Section 1983 was if their conduct was specifically authorized by state law. Monroe changed that regime and allowed plaintiffs to sue under Section 1983 for actions that were not authorized by state law or that were committed in explicit violation of state law. But it has always been the understanding under Section 1983 that an unconstitutional action that is explicitly authorized by a state statute is the very core of what Section 1983 is designed to target. Actions that violate the federal Constitution that are nevertheless committed under color of state law. And being specifically authorized by state law is as much as you can get to being under color of state law as is legally possible. Now, it's still possible to think the Supreme Court was wrong in Janus to say that this conduct violated the Constitution. It was a 5-4 decision. There was a very strong dissent from Justice Kagan. It's also possible the Supreme Court is wrong to have said that there are holdings in cases of constitutional magnitude will automatically have retroactive effect. That was a decision they made in 1993 in a case called Harper against Virginia Department of Revenue. And it repudiated the old regime from Chevron Oil that took a more contextualized approach to retroactivity in civil litigation. But the Supreme Court's holdings on those matters are binding on the lower courts. This was a violation of the plaintiff's constitutional rights, given what the Supreme Court said in Janus. And Janus is retroactive, given the holding in Harper against the Virginia Department of Revenue. To the extent there's any inequity or unfairness, there really isn't any plausible argument the union can make that it's unfair to allow the plaintiffs a remedy that merely requires the union to restore the money that the Supreme Court has said it never should have been allowed to take in the first place. And that's especially true.
How much money are you talking about, Mitchell?
Only within the statute of limitations, Judge King. We're not asking or even suggesting that the union could be on the hook for all the agency fees they took from the beginning of the agency shop arrangements. It's a small window of 2 years under Maryland law, and it would only be, if it's only these two plaintiffs, whatever amount of money they paid in agency fees during that window of time. It would be in the hundreds, perhaps a small 4-figure sum for each individual plaintiff. It wouldn't be much more than that. Now, we did bring the lawsuit as a class action, but the class hasn't been certified yet. I'm not sure whether a class would be certified under the standards of Rule 23. That would be a hotly contested issue. I know in other contexts, people who have tried to get classes certified in these refund lawsuits have not been able to do so. So it would be a small amount if these proceed as individual cases. It would be a larger amount, obviously, if a class action were certified, but we haven't gotten yet to that point in the litigation. So the other issue to consider is that the union is proposing a good faith defense that extends well beyond the qualified immunity that's available to government officers. The good faith defense has been based on the defense of qualified immunity. It's the same type of idea. A government officer who acts in reasonable reliance on a statute that is believed to be constitutional at the time is not liable for damages under the doctrine of qualified immunity. And the union is borrowing from that concept to extend that defense or that type of defense to private actors who violate Section 1983. But the union's proposing a somewhat different defense with respect to the scope. The defense of qualified immunity protects only individual government officers, not entities. Municipal corporations, for example, can't claim qualified immunity at all under Section 1983. That's the holding of Owen against the City of Independence. The union, though, says that not only individual people, but also entities such as unions and presumably municipal corporations should have a good faith defense under Section 1983 when they are acting as private parties who've violated another's constitutional rights under color of state law. It's not clear why those two situations should be treated differently with respect to qualified immunity on the one hand and the good faith defense on the other. And I see my opening time has expired. If the court has questions, I'm happy to answer them now, but otherwise I'd like to save the rest of my time for rebuttal if I could.
Thank you, Mr. Mitchell.
Thank you, Your Honors.
Mr. Diane?
Thank you, Your Honor, and may it please the court. There's a reason why there is an extraordinarily broad consensus among the circuit courts, going back to the Fifth Circuit's Wyatt decision decades ago and continuing through the recent series of post-Janus decisions in the First, Second, Third, Sixth, Seventh, and Ninth Circuits. that's 6 circuits, who have embraced the proposition that private parties who invoke presumptively valid state laws to seek the aid of government officials are not subject to monetary remedies under Section 1983, but instead are protected by a good faith defense against those particular remedies. And the reason is this. Before the Supreme Court's decision in Lugar in 1982, it was an open question whether Section 1983's under color of state law clause was even broad enough to reach private parties whose connection to state action consisted of nothing more than merely invoking a presumptively valid state statute to seek the aid of government officials. And when the court decided Lugar, even those justices in the majority who said that Section 1983 was broad enough to reach that type of private party recognized the force of a point made by the 4 dissenters. And their point was that there was a potential for serious injustice in subjecting a private party to monetary liability for invoking governmental processes in good faith reliance on a seemingly valid statute. So the Lugar majority recognized that subjecting people to monetary liability in that circumstance was a problem. That's the majority's word.
Could you address how you've established the good faith defense in this case?
Oh, sure. Well, there's no claim by the plaintiffs that the unions weren't acting in good faith, other than an allegation that that the other courts have rejected, that the union has not affirmatively proven that it complied with every aspect of the Abood regime. So, our position is that where there is, and this is what all of the circuits that have addressed this have held, that where there is a statute that authorizes the conduct complained of, and the Supreme Court has affirmatively held that statute, or one totally indistinguishable from it, to be valid. When those two things, when those confluence of things occurs, the good faith defense is established as a matter of law. And if you look at Justice Kennedy's concurrence in Wyatt, which is really the fountainhead of the good faith defense that came out of Wyatt, Justice Kennedy says that where there's reliance on a statute, that's an objective basis for finding a good faith defense, such that you don't need to do some sort of case-by-case inquiry into the particular state of mind of the particular, officials of the defendant who followed the law and followed Supreme Court precedent. And I should say that if I haven't already, all of the 6 circuits that I mentioned those cases all came in this posture on a 12b6, and in all of them the courts recognized what I just said, and that's why they affirmed 12b6 grants. So I was just going to get back to sort of the origins of the good faith defense, because I think once you understand those origins, then all of the arguments we've heard fall by the wayside. So going back to the Lugar decision in 1982, the majority responded to the dissent's concern about the injustice of subjecting private parties to monetary liability when they relied in good faith on state statutes and government officials. They responded with a footnote 23, which is critical in the development of this doctrine. The court said, this problem should be dealt with not by changing the character of the Section 1983 cause of action, but by establishing an affirmative defense to monetary liability. And then the court said that issue, however, was a remedial issue. That was the court's term, to be decided in subsequent proceedings. So that's Lugar. Then about a decade later, the Supreme Court picks up the thread in Wyatt and expresses the exact same concern for private parties who rely on presumptively valid statutes. And while the majority in Wyatt didn't reach the issue because the defendant there sought full-blown qualified immunity and not just the good faith defense being sought here, the court's reasoning, as well as that of the concurring and dissenting opinions, which did reach the issue and amounted to 5 votes that were explicit in stating that there should be a good faith defense. The court's, even the majority's reasoning, putting aside the 5 concurring and dissenting votes, the majority's reasoning pointed the way to what the lower courts uniformly have held since Wyatt, which is that there is this good faith defense to monetary liability. Now, the plaintiff here, in his brief, and we just heard Mr. Mitchell's presentation, he doesn't dispute that there is a good faith defense available to Section 1983 private party defendants. So the only question really before the court is whether the defense applies to the circumstances alleged here. And the answer is that the defense plainly does apply. There are 2 features of this case that actually make it an especially strong candidate for application of the good faith defense, stronger than the earlier generation of 1990s Court of Appeals cases that addressed good faith defense outside the labor context. And those 2 features are, first, that the union here was not merely relying on a presumptively valid state law whose validity had not been tested in court. That was the early fact pattern. That was Wyatt itself. Here, the unions were relying on state laws, and I said this before, but it bears emphasis. They were relying on state laws identical to the law in Abood, the Michigan statute, which had, of course, been tested and affirmatively declared constitutional by the highest court in the land in the Abood case. And then the second feature of this case that makes it particularly strong is that the fees that the unions collected here were required by the Maryland representation fee statute to be expended for the purpose of benefiting all employees whom the union represented, member and non-member alike. So the union, there's no dispute that the unions expended these monies for the purpose of benefiting both members and non-members like the plaintiffs. The unions didn't, as the Ninth Circuit said in Danielson, the unions did not, the union did not sort of stick these fees in a vault or put them in some segregated account to try to earn profits off of these fees. The union spent the funds that they collected on providing services to all those whom they represent, including those in the class of non-members that the plaintiffs are purporting to sue on behalf of. So, and that last fact, the fact that the funds here were expended for the purpose of benefiting those whom the union was statutorily obligated to represent, that fact alone distinguishes this case from the whole host of non-Section 1983 cases that Mr. Mitchell cites. In none of those cases was there a Section 1983 claim, and in none of them did the defendant accept the money or property and then expend it under a statutory duty or other duty towards others so that the funds were not available and segregated such that they could easily be returned. In each case, and I think the multiple courts have addressed this, the Ninth Circuit in Danielson, Judge Wood's opinion for the Seventh Circuit in Janus on remand, explained that you can't unscramble the egg here. And that distinguishes this case from the kinds of cases that Mr. Mitchell has cited. Now, I want to address the restitutionary theory that's really at the heart of Mr. Mitchell's presentation to this court. The first argument is that's been made in the briefs by Mr. Mitchell is that the good faith defense does not apply where a plaintiff is seeking equitable relief. And Mr. Mitchell asserts that the restitutionary relief being sought here is a form of equitable relief. And I think this argument is wrong. It rests on 2 premises, both of which have to be correct for the argument to succeed, and neither one of which is correct. The first premise of the argument is that a person seeking the return of money or property unconstitutionally transferred to a third party isn't pursuing an action at law for damages, but is instead pursuing a remedy that sounds in equity for equitable restitution. And the second premise is that there's no good faith defense to actions in equity that would seek a refund of money unconstitutionally transferred. And as I said, both of these would have to be right for the plaintiffs to even get their foot in the door here, and they're both wrong. As to the first premise, I think it suffices to say that the Supreme Court's decisions in Knudsen and Montanil, and we discussed those cases at length in our briefs, those cases reject that first premise. They explain that an action to seek money from the defendant to compensate for a loss to the plaintiff is an action at law, not equity, unless at a minimum the money was sequestered in a segregated account. And the Seventh Circuit's decision in Mooney addresses this thoroughly. The Ninth Circuit's decision in Danielson, the Sixth Circuit's decision in Lee, all reject that premise on the grounds I just stated. The union's general treasury does not qualify as a segregated account under those cases and under the Supreme Court cases that they follow. And then there's an equally fundamental problem with calling this or labeling this something other than damages and trying to call it restitution. Was there a question for me? Okay, I'm sorry. Yeah, go
right ahead.
Oh, I'm sorry. Yeah, so it's conceptually wrong, I think, to think of it as something other than damages, because restitution is, of course, measured by the defendant's gain or unjust profit and not by the plaintiff's loss. And these fees are just an effort to recoup the plaintiff's losses, so they're classic damages. There's no allegation, nor could there be, that the union's made any net profit off of agency fees, because the entire structure of the Maryland representation fee system was that those fees could be collected, but only if expended, and only if expended to benefit member and non-member alike on representational activities. So that's just the first premise of the restitution argument being wrong. The second premise, which assumes that if you can label the thing or the kind of cause of action equitable restitution, then the good faith defense somehow disappears. That's also incorrect. And that's because the Supreme Court recognized in the Lemon 2 case, that's the less famous Lemon versus Kurtzman case. It was a follow-on to that Establishment Clause case, where the court said that those religious programs that had already committed funds in reliance on, I believe it was a New York statute that was declared unconstitutional in Lemon 1. In Lemon 2, the court said, well, wait, those religious entities who received these monies, though we now know they were transferred in violation of the Establishment Clause, they do not need to return that money. In fact, the court even said that for work already performed where they hadn't even collected, they could collect, the payments that would make them, that would not put them out of pocket, so to speak. So, this is how far afield it goes, that even if you call it equitable, there's still a good faith defense under Lemon, as well as in the Ellis case, which was an agency fee case, post-Abood, where the court found that one of the expenditures that the union made it really exceeded the union's authority under the Abood doctrine, but the court still didn't require in addressing the remedy, the court said the union did not have to return those funds because they had been expended on a program that was of benefit to non-members. So this supposed universal principle that the plaintiffs rely on really isn't universal at all. It's inconsistent with those Supreme Court cases that I just referenced. For good measure, it's also inconsistent with the common law approach to addressing the situation where a plaintiff has paid money to a defendant pursuant to a seemingly valid law, and the defendant then expended the money in good faith before the law was found invalid. We cited, we cited sections from the restatements on restitution in our briefs that lay out that principle and cite cases where a defendant who, again, both collected and expended monies in good faith reliance on a statute later declared unconstitutional, was permitted to retain those funds, and the plaintiff was denied a restitutionary remedy. So, I mean, there's that there's really, I think it's unusual in this era, I think, to see 6 circuits looking at the same problem, for the first time in the wake of Janus, and all coming to the same conclusion. And I think the reason that they have done so is because the good faith defense is solidly grounded in those Supreme Court cases, Lugar and Wyatt, and solidly grounded in the Court of Appeals cases that immediately followed them. And there is a common law basis for the defense, in that, as I think the most clear exposition of this was Judge Sutton's opinion for the Sixth Circuit in the Ogle case. The courts have said that the 1870 Congress that adopted Section 1983 would have been very surprised to see a private party who, in reliance on a state statute and procedure, would be required to return monies collected and expended in good faith, because unlike a private party guilty of the tort of conversion who is resorting to self-help, a party that is going through channels and going through law and following statutes and official procedures to secure money or property from another would only be found responsible for and damages to the person if, in fact, they were abusing the process and not acting in good faith. And that's why the circuits have said that the most analogous tort is the abusive process tort, because the unions here, again, we're not resorting to self-help, but we're following state law and state processes in collecting and expending these agency fees. And since at common law, a party relying in good faith on state laws and procedures would only be found liable if they had malice and lack good cause for doing what they were doing at the time, there should be no liability here. And that, unless the court has questions, I'll conclude.
Thank you very much. We appreciate that. Good job. Mr. Mitchell?
Thank you, Your Honors. Judge Floyd, in response to your earlier question, I did look at our district court briefing and have the pin site to provide for you if needed, but it's on page 29 of our district court brief, which is ECF document number 86, where we specifically assert that the good faith defense cannot confer an immunity from a restitutionary remedy or a remedy that is trying to pursue unjust enrichment or the recovery of an unjust enrichment that the defendant obtained. To be clear, and Mr. Diane said this during his presentation, we're not disagreeing with the unions over the existence of the good faith defense. Our disagreement concerns the scope of this defense. And our claim is not that the good faith defense is categorically unavailable. Our claim is that if one assumes the existence of the good faith defense, consistent with rulings from other courts of appeals that have held that private defendants can assert a good faith defense under Section 1983, that defense cannot extend so far as to protect a defendant from a remedy that merely seeks the return of money or property that has been taken in violation of another's constitutional rights. There's no example from any other area of law where a defendant who takes money or property in admitted good faith in reliance on a statute that is later declared unconstitutional is then allowed to keep the money or property that was taken on the ground that the defendant believed his conduct to be constitutional at the time that he acted. And Mr. Diane suggests that there are two features of this case that make it different from the other cases that we cite in our briefs. One point he makes is that the union in this case was relying not only on a state law enacted by the Maryland legislature, they were relying on a state law that the Supreme Court of the United States had upheld in Abood before Abood was overruled. So they were relying on essentially more than just a state statute. They were relying on a state statute combined with a Supreme Court pronouncement that had appeared to bless the constitutionality of that statute. And Mr. Diane is factually correct to make that observation, but it doesn't distinguish the authorities we're relying on, because in United States against Windsor, the IRS had collected taxes in reliance on the Defense of Marriage Act, a federal statute, but also in reliance on Baker against Nelson, which was still the law in 2013, and which had indicated that statutes that define marriage as the union between a man and a woman are constitutional, and that the idea of a constitutional challenge to statutes of this sort would not even present a federal question under Article 3 of the Constitution. So in like manner, the IRS was relying on a federal statute, a congressional enactment, as well as a Supreme Court decision. And they still had to return the money, and properly so. They should have had to return the money, given the holding of the Supreme Court that it was taken in violation of the Constitution. That money was taken in good faith, to be sure. They relied on the statute, just as the union did, and they relied on the Supreme Court decision, just as the union did, but they still had to return the money. Good faith and qualified immunity would protect individual IRS agents from liability if Ms. Windsor had tried to sue them for additional damages or collateral harms that had been inflicted by the unconstitutional seizure of her money. She could not, for example, maintain a claim against the IRS officers who collected her taxes for infliction of emotional distress. That would be barred by qualified immunity, or if one prefers, it would be barred by the good faith defense. But neither of those defenses would allow the government to keep the money. The second point that Mr. Diane makes is that this money that was taken from the plaintiffs was used to benefit union members and non-union members alike. And again, Mr. Diane is factually correct to observe that the union was under a statutory duty to represent all members of the bargaining unit without discrimination based on their status as a union member. But again, this fact was equally present in Windsor. The taxes that were collected from Ms. Windsor were deposited in the federal treasury to be spent for the benefit of all Americans, including Ms. Windsor, who had her money wrongfully taken from her. And again, that could not be used to defend the idea that the federal government could keep money that was taken in good faith, but nonetheless in violation of another person's constitutional rights. This is an unusual case. We don't see many lawsuits that are brought against private defendants under Section 1983. That itself makes this case somewhat unusual. And that's why there aren't many cases on the good faith defense. There are, to my knowledge, the Fourth Circuit has never issued a ruling on whether the good faith defense even exists. And the cases that come from other courts are few and far between. So there isn't much case law out there defining the scope of this defense until these union refund lawsuits were being brought in the wake of Janus. But I want to make another point about Mr. Diane and whether this is an equitable remedy. Mr. Diane, during his argument, cited Lemon against Kurtzman on remand to the Eighth Circuit. But this case does nothing to support the argument for a good faith defense, and I want to explain why. The plurality opinion in Lemon explained that the reason it would not force those school districts to return the funds was because that the holding of Lemon against Kurtzman was not retroactive under the three-part test for retroactivity established in Chevron Oil, which was the law governing retroactivity at that time. This was not a case that held that there was a good faith defense. Lemon against Kurtzman is a case that held that the holding on the constitutional point was not even retroactive in the first place. And that was a plausible holding in the 1970s when the three-part test from Chevron Oil governed the retroactivity question. That's not the case today because Harper overruled Chevron Oil, and Harper holds that all Supreme Court rulings are retroactive automatically, and there's no more contextualized three-part test that's applied under Chevron Oil. So the Lemon against Kurtzman test doesn't do anything to support the claim for a good faith defense and why good faith as a defense should allow the union to keep the money here. And I'm running short on my time. If the court has further questions, I'm happy to answer them. But if not, I will yield my time back to the court.
Judge Floyd, Judge Thacker, you have further questions?
No, sir.
No, I don't.
Thank you, Your Honors.
Thank you very much, Mr. Mitchell. if we were in Richmond with you, we would at this time leave the bench and come to the well of the court and greet each of the lawyers and commend them on their efforts. So you have to use your imagination in that score today. Hopefully won't be long. We'll be back to Richmond to hear our cases, but we will take your case under advisement, and we have one additional case to consider today, here today. But before that, contact the lawyers and call the next.
And may it please the court. I am representing Ms. Dowling as the appellant in this case. It's a Social Security disability case. Procedurally, just very briefly, Ms. Dowling had been approved in a prior application and had been found disabled as of April 15th of 2009. This case involves a review of her prior finding of disability, and she was found to be not disabled at the initial levels up through the hearing process. And of course, a decision was issued in this case in 2016, again, finding that her condition had improved, and therefore she was no longer disabled as of March of 2013, March 31st of 2013. So, in my brief,
she was found disabled for 4 years. Is that correct, Sam?
That's approximately 4 years. Yes, Your Honor. Thank you. Basically, in my brief, I point out a few things, issues that are probably, the general issues are pretty familiar with the court probably in terms of these type cases. They're issues that come up frequently. First of all, the consideration of the treating opinion. Of course, there have been changes in those federal regulations in the last few years, but of course the prior regulations would apply in this case. And, the one thing that we point out is in terms of the treating physician here, Dr. Gross had provided an opinion that Ms. Dowling would have a very limited ability to sit. That's it. In the transcript in a basically disability questionnaire form. And Dr. Gross indicated that her ability to, Ms. Dowling's ability to sit would be less than 2 hours a day. A big part of the problem here in terms of Ms. Dowling's condition is that as a result of her colitis, ulcerative colitis, and things
What was Dr. Gross's medical opinion?
You mean generally, or?
Well, I know Dr. Gross had an opinion that appellate was, quote, not able to work, but that's not a medical opinion, is it, for purposes of this case?
Oh, no, Your Honor. Dr. Gross did provide a general statement that she was disabled, but Dr. Gross also provided a very specific assessment of Ms. Dowling's limitations that are in the transcript at page 773 through 775. And
who said she had colitis or Crohn's disease? I'd like to know that.
Well, that was basically the original finding of her disability. I can't honestly from memory tell you the original sort of doctor who made the finding on that, but
you called it colitis, and you just said a few minutes ago that she had ulcerative colitis. That's a serious ailment. Now the government acknowledges that she had colitis or Crohn's disease, and they drop a footnote in and basically tell us that doesn't make it does not any difference, but there is a big difference. Or there can be.
Right.
My understanding, Crohn's disease is more serious than ulcerative colitis.
Yes, Your Honor. And the judge in the hearing decision did find, if you look at page 31 of the joint appendix, did find that both of those conditions were severe impairments. So I don't think there's any contention, or I don't think there's any dispute among the parties that those were both severe impairments that Ms. Dowling
are those? Is that in 2009 or 2013 or when?
That was as of. No. The judge, if you look in the hearing decision, made findings.
I'm not looking at the hearing decision. I'm asking you. I want to know when she was determined. When it was determined she had ulcerative colitis. When it was determined she had Crohn's disease.
Well, Your Honor, that was the original finding that led to the disability. But in the hearing decision, was
that in 2009 then?
Yes, Your Honor. Yes,
as ulcerative colitis. She says ulcerative colitis or Crohn's disease for 11 years. You don't get well if you have Crohn's disease or ulcerative colitis. You don't get well. You have it.
Yeah. Yes, Your Honor.
My understanding. Now, maybe I'm wrong, but
I'm going to be honest and tell you I am not. I'm sorry. I apologize. I did not mean to interrupt, but and I understand the point you're making, and all I can tell you is in terms of I'm certainly not a medical expert, so I can't speak in a lot of detail about. I know generally from handling these cases that both of these conditions.
But you're more familiar with this record than we are. I think you should be.
Right. Well, I can tell you that the judge, the relevant legal issue is that the judge did find that she continued to have those conditions continuing to exist through the period of under review here. He did find that there was medical improvement and that she was doing better with these conditions. He did not specifically address what you're saying about, that with Crohn's disease and how that improvement specifically could occur. He did note in the records that symptoms were doing better, but he did find
there are medications for them that put some of them in remission, but it's my understanding they don't heal. They don't go away. Anyway.
Right. And part of the problem here is, and it's really reflected in the record, is that these are waxing and waning type conditions. There certainly is evidence that there was significant improvement when, prior to this judge finding that that medical improvement did occur. But if I could sort of get to, the crux of my argument, Dr. Gross, the treating physician, did find that there would be significant sitting limitations. And part of that, and it is true that Dr. Gross sort of listed some conditions on the form. But my argument is you have to combine the treatment notes from Dr. Gross, which specifically cites the problems that Ms. Dowling was having with sitting due to her fistula and pilonidal sinus condition that Dr. Gross specifically noted in the record that she was having problems and pain with sitting as a result of that condition.
And are those conditions side effects of the colitis, Crohn's disease?
That's my understanding, Your Honor. Yes, the sinus can be a result of the problems from that. That's absolutely correct. That's my understanding, anyway.
That's what the medical people think too, right? Not just lawyer.
Right. And I would like to point out, I think on this point, if you look at the appellee's brief, it's sort of the appellee describes the improvement leading to the cessation of disability, and then suggests that this whole thing with the fissure, the sinus, this open basically area there that was causing a lot of problems developed sometime after that. But if you look at the actual medical record, it's clear that the medical records, to the best I could determine, don't show exactly when this problem started, but it's clear that it was going on at least approximately around the time that the disability benefits were cut off. And specifically at page 501 of the transcript, when she goes to Dr. Gross, Dr. Gross notes that she continues to have the fissure and describes what she's trying to do to maintain it and take care of that. And that's a record from May 9th, which was, less than just a little bit over a month after the disability ceased. But I did want to just, so one thing, there's a couple of key points here that I really want the court to consider. One is that if you look at the hearing decision, there's no discussion whatsoever of the obesity. And there is clear evidence that Ms. Dowling, unfortunately, was very obese. The records document a number of times her BMI. Examples would be page 728 and 729 of the transcript that provide a chart showing at different dates what her BMI was. It tended to range from 38.
Tell me what BMI means. Tell me what BMI means.
I'm sorry. Yes, Your Honor. The body mass index. And that's
body mass index. There you go. I think I know more about Crohn's disease than I do about body mass index, but go ahead.
Okay. Well, BMI is basically a statistic to tell you how much.
I understand now.
Okay. All right. So her BMI, which is that showing basically the amount of obesity, ranged from 38 through 41 to 42 in the records, which is significantly obese. It's between class 2 and class 3 obesity. And so her doctor actually specifically found that, or noted that trying to do a surgery to repair her fistula would be very much complicated by the obesity. And so it's clear that the obesity was a significant issue in this case. And I think logically, though the commissioner correctly, notes, and it is true, I would concede, that Ms. Dowling isn't complaining about the obesity specifically to Social Security as a reason she's disabled. I think the record pretty clearly shows that it was a complicating factor here. And, she talks to her doctor about her problem with sitting and pain with sitting. And I think it's just reasonable and logical to conclude that the obesity would be aggravating that, given the extent of it. The judge.
And which factor does that go to that the ALJ didn't consider?
He doesn't consider it at all. He doesn't make a finding as to whether it's.
I know. And all right. So the ALJ was to engage in a function by function analysis. Which particular function does not, considering the obesity, go to?
Your Honor, I would argue that would certainly go to the sitting issue. And the judge notes, he specifically notes, and I find this, again, very important. If you look at the step 1 analysis in the hearing decision, this is page 33 of the joint transcript, a joint appendix, the judge notes that Ms. Dowling alleges problems with sitting due to her fistula. He specifically notes that in the decision. And then he states immediately thereafter, even though the claimant has medically determinable impairments that could reasonably cause some of her reported symptoms, the objective evidence does not support the alleged severity. So he concedes that the symptoms she alleges, which includes the problem sitting, are documented and supported, but he just finds that they're not as severe as she suggests. But he included no restriction on sitting in the hearing decision, and she's limited only to a range of sedentary work, which of course would generally be primarily sitting. And therefore, I would also I'm running out of time. I did want to note too, the only other exam or opinion that provides specific restrictions in the file from somebody who's actually evaluated the claimant, hands-on evaluation, was the consultative exam by Dr. Hare, who also limited Dowling to 4 hours sitting total. And I'll stop right there.
Judge Thacker, Judge Floyd, you have any further questions? Mr. Mays?
No, I don't.
Not right now, thank you.
Let's hear from the government.
Thank you, Your Honors. Good morning, and may it please the court. I'm Brittany Gelati, appearing on behalf of the Commissioner of Social Security. And I'll start with some of the backgrounds that your honors were asking about, which is that, as we know, Ms. Dowling was previously awarded benefits at age 30, and that was due to a flare in her Crohn's disease that she had, and it was caused by sepsis. And so the ALJ, who was reviewing her case at that time, he understood that Dowling's condition was disabling following her contraction of sepsis, but the ALJ expected that her condition would improve with medication. And so when the agency did a continuing disability review in 2013 to see whether there was medical improvement, as that previous ALJ had anticipated, there had been. And so the treatment notes from Dowling's gastroenterologist at that time showed that her disease was quiescent and it had gone into excellent clinical remission. And so your honors are correct that Crohn's disease is a lifelong condition, but Ms. Dowling, and the record shows, and as the ALJ noted, her disease was doing well on her medication, and so her benefits were ended. But then Ms. Dowling, she had an unrelated surgery later, 2013 or 2014, where she took some pain medication, and that caused constipation. And so as a result of constipation, she developed this new issue, which was a pilonidal sinus, a fissure, or a perianal fistula. And those are all terms that are used in the record that pertain to this same wound that's at the top of her buttocks. And so,
and those conditions are typical of individuals who have Crohn's disease.
Sure. And so the ALJ did a very thorough job here. He understood this condition, he understood the full record, and he explained that this sinus, as I'll call it.
Wait, but he didn't really do a very thorough job with regard to Dr. Gross's opinion. Did he consider all 6 of the 404 factors?
Yes, Your Honor, he did. So, and he,
okay, so where?
Well, specifically with regard to sitting, the ALJ discussed sitting very thoroughly, and he understood, and he discussed on page 14 of the joint appendix that Dowling, or on page 12, I believe, that Dowling did report some problems when she sat for a long time. But the ALJ also knew that at the time Dr. Gross rendered her opinion, her treatment notes, for instance, on transcript page 912, showed that that sinus was healing well and that her Crohn's disease was controlled. And the ALJ also talked on joint appendix page 14 about treatment notes from gastroenterologist Dr. Morali. They said the same thing, that Dowling's Crohn's disease was in excellent remission and that her sinus was almost completely healed with medication. And the ALJ also explained that Dr. Gross's opinion here conflicted with the generally normal examination findings of consultative examiner Dr. Harris.
Can you stop talking for a second? I have a question.
Yes, Your Honor.
And I don't think you answered it in the first place. Where did the ALJ discuss the length of the treating relationship and the frequency of examination in connection with Dr. Gross? Let's start there.
On pages 14 and 15 of the joint appendix, Your Honors, the ALJ gave a detailed discussion of Dowling's colitis, the fact that it was in clinical remission, her benefits were ended, and then he discussed her treatment notes. And I will add that Dr. Gross is a family physician, so she was aware of Dowling's Crohn's disease and also aware of this sinus, but Dr. Morali was the gastroenterologist who was treating.
Right, I'm asking about Dr. Gross.
Sure.
So, and also where in the record did the ALJ discuss factor number 2, the nature and extent of the treatment?
Sure, so the ALJ discussed on page 13 that Dr. Gross was a treating family practitioner. She was the claimant's treating family practitioner. And he discussed that, she treated her for, all different family type things. So Dr. Gross was generally aware of claimant's impairments, mental, physical, whatever it was. And the ALJ's discussions on pages 13, 14, and into 15 thoroughly discuss, the full picture here, the fact that Dowling had Crohn's disease, that she had remission, that she did for a period of time go off her Remicade medication, and that she was reporting some symptoms again. But the ALJ understood that that was a period of time when she had gone off the medicine. So again, he looked here at the—
Right. I have another question. If we disagree with you and find that the ALJ was required to but did not consider each of those factors, do we need to reverse and remand on that basis? What is your argument on that?
So you're saying if Your Honor is finding that the ALJ did not consider those factors, well, yes, that would be a finding of fact for the ALJ. But again, Your Honor, I think
and so then we would have to, if we disagree with you, I'm not saying necessarily that I do, but if we do, then you can see that we would need to reverse and remand on that basis because it's a factual matter.
Well, I don't think so. I guess as opposed to an award of benefits, is that what you're asking? Because my understanding are the court could affirm and find that the ALJ did consider Dr. Gross's findings and opinion, or if the court believes that the ALJ did not, then it would be to remand the ALJ for further consideration of Dr. Gross's findings. But again, I'm not sure what the court thinks the ALJ should have further considered here. He looked at Dr. Gross's findings in detail, and he had a very clear picture of Miss Dowling. And he also knew that she was working. Miss Dowling was working 12-hour shifts once a week as a home health aide, which is a medium exertional job. And that contemplates sitting 6 hours a day, standing 6 hours a day, or walking 6 hours a day in an 8-hour day. And here she was doing this for 12 hours a day. And she didn't allege that she had problems sitting.
But didn't the ALJ only mention her inability to sit one time?
No, Your Honor.
In the ALJ opinion?
The ALJ looked at her. He discussed that she reported some issues sitting for a long time, but he also looked at her activities, for instance. And he talked about on page 18 that she preferred to grocery shop while sitting in a cart. That she was working, as I said, 12-hour shifts as a home health aide, which is medium work and contemplates sitting for 6 hours in an 8-hour day. And the ALJ looked at the treatment notes, which is very important here and can't be overstated because the treatment notes.
How often did she do that 12-hour shift?
She did it once per week, Your Honor, and she testified that she didn't work more because the old lady that she was helping didn't request her to come more than that. And she would sometimes pick up additional shifts about 1 to 2 times per month when requested. And she said that the reason that she maybe didn't think she could work full time was because it was night shifts and she might get tired, but it had nothing to do with problems sitting, needing to use a restroom. There was nothing in the record where Miss Dowling was saying she couldn't perform this job because of her Crohn's disease, and I think that's extremely important.
Ms. Gigliotti, this is Judge Floyd. Do you dispute that the ALJ did not conduct a function-by-function analysis of Dowling's limitations?
Yes, I strongly dispute that, Your Honor. I believe that he did.
Well, how about the conflicting evidence about Dowling's ability to sit for long periods and use the restroom?
Sure. So the ALJ, he talked about that, Your Honor, and it's important here. So it's an ALJ's duty to look at all of the evidence in the record, including the conflicting evidence, and then to weigh that evidence. And so we look at this from the substantial evidence standpoint, and it's not a question of would we have made this same decision or how would we have weighed the evidence. So under the law, we look to see, did the ALJ point to substantial evidence? And so he did here, Your Honor. He discussed Dowling's ability to sit, and he understood her complaints of trouble sitting for long periods, but he explained that he didn't think that Dowling was more limited than his residual functional capacity finding. And he pointed to examination findings showing that her sinus was healing when she was on the proper medication. He pointed to the fact that Dowling reported that she preferred to sit when she did different chores, when she went grocery shopping. He looked at Dr. Hare's report, which is important here. Dr. Hare did a full exam. She noted that Dowling had Crohn's disease, that it was on the proper medication, but nothing about the sinus came up in that examination. Dowling didn't say that she had any trouble sitting when Dr. Hayes was examining her. So I think that's very important. The ALJ talked about that on page 15. The ALJ talked on page 18 that Dowling's physician in June of 2015 said, quote, her conditions were not activity limiting. That was on page 894. So the ALJ did his duty here. He understood what Dowling's complaints were, and he weighed that against all of the evidence in the record, and he pointed to the substantial evidence to support his findings, which the Supreme Court in BSTEC noted is only more than a mere scintilla of evidence, and it's enough that a reasonable mind might find that there's enough to support. And here, there is absolutely enough evidence to meet that substantial evidence. And yes, Your Honor? So even if plaintiff can also, or Dowling, I should say, can also point to other evidence, that doesn't negate the substantial evidence that the ALJ did rely on here. Now I'd like to discuss my colleague's claims about obesity, Your Honor. And it's important that Dowling never alleged that obesity was disabling, and neither did Dr. Gross or any other physician. She didn't identify it as an impairment in her disability application. She didn't testify as to any limitations from obesity, neither did her physicians. And on page 114 of the joint appendix, the magistrate judge noted that Dowling listed 11 different impairments in her pre-hearing brief, but not obesity. And so Dowling said, as the ALJ considered, that it hurt when she sat for a long time, but she didn't say that obesity impeded her. And even if the ALJ could have said more on obesity, any error is harmless here, given that the ALJ addressed Dowling's ability to sit and he addressed her sinus. So I think that's very important. And also with regard to surgery, which my colleague brings up, we think that this argument is a red herring because the ALJ specifically considered on page 17 that her gastroenterologist, Dr. Morali, thought that Dowling's sinus could require surgery, but the ALJ noted that Dr. Morali wanted to try Remicade first. And as the ALJ's discussion makes clear on pages 14 and 15, surgery wasn't needed because the Remicade was effective in healing the sinus. And after just a few treatments, Dowling's sinus was almost completely healed, which we can see on transcript page 577. And again, to the extent that she had further issues with that sinus, the ALJ explained on pages 15 and 16 that this was during a period when Dowling stopped taking her medication because the insurance stopped covering it. But once she went back on her medication, she began healing again. So, Your Honors, this ALJ, he had the full picture here. He understood Dowling's complaints. He weighed all of the evidence, and he rendered a finding that is supported by substantial evidence. Do Your Honors have any additional questions for me?
No, I don't.
Thank you, Ms. Gigliotti. I don't believe we do. Mr. Mays got a couple minutes saved back. Mr. Mays?
Thank you, Your Honor. I do need to address several things that were raised there that I believe are important for the court to consider. First of all, regarding the obesity and the failure of the of Ms. Dowling to specifically raise that, the administrative judge is required to consider evidence of impairments, regardless of whether the claimant is wise enough to, bring those things up or raise them. She did have a non-attorney representative at the hearing. Ideally, the obesity would have been specifically brought up. However, if you look at Social Security ruling 02-1P, which was the ruling that was in effect at the time that that this case was considered relating to obesity. It specifically talks about if there's a high BMI, again, body mass index, that's in the 30s, that would be something that would sort of maybe require, or that the administrative judge should contact a doctor to see the impact of the obesity. So the ruling does note that the judge should be looking at those issues and the evidence and address that. I wanted to specifically quickly address the work issue that I think it's to my client's benefit, or it's admirable that she's done what she can to return to work, but she was working and it was classified as medium. This was a limited, she was going once a week to an elderly woman's house to help her with medications and some light meals and things. She has access to a bathroom. I did want to also mention, related to that, there's plenty of evidence. The judge concedes in the hearing decision that the problems with incontinence continued, but he dismissed it as a not severe problem because she said she wore pads. But she's still going to have access to a bathroom. You can't work throughout the day without changing those pads periodically. And again, that was not factored. There was not that function by function that's required by the Fourth Circuit.
Thank you, Mr. Mays.
Thank you, Your Honor.
If we could do so, we'd leave the bench and shake hands with you lawyers from South Carolina and tell you did a fine job. But we can't do that today. So we'll just have to take the case under advisement. You say something, Mr. Mays?
I'm sorry, Your Honor. I just said I really appreciate that.
Well, we appreciate your work. We appreciate your work, Mr. Gigliotti. Good to have you here. But we'll take your case under advisement and adjourn court for the day.
Thank you. Y'all have a good day.
Thank you, Your Honors.
This honorable court stands
adjourned until this afternoon. God save the United States and this honorable court.
Judges,
Madam Clerk?
Yes.
At what point are we